All right, looks like we're live. Hopefully this is working okay. We'll see if people show up. This is kind of a test run. I haven't done a live webinar in a while, but I want to make sure I'm doing this correctly. It looks like we got 6 people in so far. So if you can just leave me a message in the chat, let me know you can hear me. Ron's here. Good to see you, Ron. If you can let me know if you hear me, I would appreciate it. I'm about to start the presentation here. Let's see. This is as much a test as is anything else. I'm going to be doing these. My plan is to be doing these on a regular basis. Let's see, slides. And I apologize for a little bit of a delay getting in here today. This is still relatively new to me. But so today what I want to talk with you about are some of the myths that, and let me just make sure people can hear me. Stan says yes, loud and clear. Catherine says yes, can see and hear you. Miss Mess, all good on audio, great. Yeah, it's been a hot minute since I have done a webinar, probably about 3 or 4 years, I would say. So this is something they were always very popular and people really seem to enjoy them. So I'm gonna try and do this again. Ms. Mez says audio good, great. Feel free to, just a couple things I'll let you know as I go through this. Number one, if you've got questions, go ahead and put them in the chat. This is just me running this today, and in the future, I may bring my legal assistant on to assist. But for today, I'm just doing this myself. Feel free to leave chats. I'm going to go back and forth between the presentation and the slides. Let me see. I'm going to turn my screen share on, and I'm going to see. I just have to do one thing, and then we should be ready to go. So let's see, slideshow. Sorry. All right. Sorry if I'm being a little bit quiet here. I'm going to just go ahead. I think the way I'm going to do this today is I'm just going to use the slides that I've already uploaded to. All right, I think this is good. I'm going to go ahead and start this. So you should be able to see this. And it looks like my face is covering up the wrong section. It should be on the other side, but that's all right. So today we're going to be talking about, among other things, 3 myths that can kill your brand before you even launch. And now that you see that, let's just go through. Let me know if you can see the slides. You probably can. Again, I apologize for the delay, but this is kind of, this is what happens the first time you do a webinar after a while. And I apologize if you hear the background noise. My air conditioning, of course, just kicked on. But let's go through this here. All right, so welcome. So today we're going to be going through some of the myths about trademarking your brand, and we're going to go through some case studies. We're going to talk about who should DIY their trademark, who should use a law firm, and then if you want to stay to the very end, I've got a special offer I'm going to be making to everyone who attends today, and they can save you money on your trademark if you're looking to hire my firm to do that. And so and I guess we just kind of talked about this. So today we're going to be talking about the truth, the myths about protecting your brand, some 3 of the most dangerous trademark myths that these are things that I get from clients and prospects on almost a daily basis. We do lots of strategy calls each week, and this is something that people ask us about all the time. And these are things that the questions and concerns that people have. We're also going to talk about some real life horror stories of trademarks gone bad and how not to let that happen to you, and then how to do what you need to do to protect your brand and your business today. All right. So let's start with why does this matter? And by this, I'm really talking about trademarks. Why do trademarks matter? Well, they matter because they have real life implications. And so this is the first example. I've talked about this example in prior presentations. I want to talk about it again here today. And if you give me 1 second, I still can't move this over. I really get annoyed by this image in the bottom here. So in 1957, the story started probably a little bit earlier than that, but this is near and dear to my heart because my father actually lives in Mattoon, Illinois, and I remember as a kid him taking me to this Burger King to get burgers. Um, so this is a small little mom and pop burger shop. It was opened in Illinois in 1957. They went ahead and registered the name Burger King in 1959 with the state of Illinois. So basically what they did is they filed a state level trademark. And I apologize for those of you that don't know, I did tear my Achilles earlier this month, and I had surgery, and I'm still recovering from that. So I have to keep my leg up on a stool so it doesn't get all swollen. Anyway, they registered their name at the state level. Now that's a question that I get asked about from prospective clients all the time. Why don't I just register at this state level? This should be fine. I don't need a national trademark. Well, what happened? Well, the national Burger King chain, which was from Florida, expanded into Illinois and started opening up stores. And once they had around 50 stores, this little mom and pop shop said, you know what, this could be a problem for us. We need to do something about this because this big, large brand that now has 50 stores across the state of Illinois is basically infringing on our trademark. We already had the trademark. They thought that by filing at the state level, they were protected from these national chains coming in. Well, there's something called every law student learns this, in the first year of law school. It's called the preemption doctrine. It basically means that any federal law, if it conflicts with a state law, the federal law is going to trump. So when it comes to trademarks, a federal trademark is going to be better than a state trademark. So what the court found in this case was that Burger King, even though it came in after the fact, it owns the rights to the name Burger King by virtue of the fact that it had a federal trademark. So their federal trademark rights trump the state trademark rights. However, because the Burger King that was operating in Mattoon, they still had common law rights and they had these state trademark rights. So basically what happened when all this was said and done, the mom and pop Burger King received exclusive rights to open up as many stores as they wanted within a 20-mile radius of their existing store. Now they only have one store in downtown Mattoon. I don't believe they've opened up any other Burger Kings within that 20-mile radius. And to this day, there is no national Burger King within that 20-mile radius. But they do have now 319 locations in Illinois outside that 20-mile radius. So obviously the national Burger King chain is doing quite fine. They did at the time back in the 50s, and you can imagine how much money this would have been worth if this was happened, in present day. But back in the 50s, the Florida chain offered $10,000 to the Burger King in Mattoon to basically take over the rights to the name Burger King, and they turned them down. I can only imagine in this day and age, that's probably $1 million. I don't know. It's with inflation, that's a lot of money. And so you can see how if they had just filed that trademark at the federal level instead of the state level, well, now Burger King, number one, they wouldn't have been able to even go into Illinois, let alone any other state. And if they wanted that name, they probably would have had to pay a lot more money to the Burger King. And who knows what would have happened? Maybe there wouldn't be a Burger King as we know it today. Maybe it would be something else. It's hard to say what would happen. Maybe this family that started this restaurant would be a whole lot richer than they are because they had just protected their federal trademark rights. Stefania says, thank you for doing this live webinar. We can see the slides. My question for today is the process any easier to get approved once a trademark has been already approved by a different organization since its EU IPO? There's a lot going on there. I'm going to hold that off for the end So I'm going to do a live Q&A here at the end of this registration. So Stefania, if you want to hold that question for now, or put it in the Q&A section, that would be great. So another example of this, and this happened much more recently, but this is called PlantMade. PlantMade is a UK brand that created natural hair products, and they had grown their business to using the name Planted to over £1 million per year in sales. And then they received a cease and desist letter. Now, for those of you who are saying, well, wait a minute, this was in Europe, this is in the UK, this wasn't in the United States. How does that matter? Well, it does matter because the trademark system is very similar across different countries. So the UK has a trademark system just the way we do, and it works very similar to the way the United States trademark system works. So anyway, this company was started called Planted. After they generated around $1 million in sales within their first year, they received a cease and desist letter indicating that that name had already been trademarked. They did not do a search before they started branding their business. So basically, this company was forced to halt their operations for 3 months, and then they rebranded to PlantMade. The owner of this brand said that pausing for 3 months, because their momentum was going so strong, they were generating sales so quickly and doing such a good job, it was devastating. They lost hundreds of thousands of pounds in lost sales, and it also cost them about £25,000 in legal fees to deal with all this. So the lesson here is delaying your trademark registration can always lead to unforeseen legal challenges, rebranding costs, and loss of business momentum. So it's not something you want to do. And I have actually dealt with this with a number of clients over the years. All right, the third example case study I have for you today is the danger of using common industry terms. And so a lot of people think, okay, there might be, can I use a trademark? Can I use common industry terms in my business? This is not necessarily something you want to trademark, but just, can you do that? Well, there is a Swedish AI startup called Lovable, and they're using the term dev mode for one of their product features. The problem is there's another company called Figma that trademarked that term in 2024. And Figma issued a cease and desist letter to them. They asserted they've got trademark infringement, despite the fact that dev mode is a commonly used industry term in AI and programming and those type of things. So my understanding of what's going on with this is it's still outstanding because the CEO of Lovable has basically said they're not going to back down. They're going to continue forward and try and use this term. I imagine this will end up in a settlement proceeding at some point. But for right now, this is likely headed to court. It's going to be a lot of money in legal fees for probably both companies. Who knows what happens out of this? I suspect what will happen is because Figma already has a trademark for this name, that it's likely that dev mode is going to probably end up paying a lot of money to fight this if they do decide to go that direction. So even commonly used industry terms can be trademarked. Another good example of this is pickleball. That's actually a trademark term. A lot of people don't know that. I only know that because I have several clients that are in the pickleball industry, and we've tried to use that term in their applications, and it's been a problem because there is another company out there that registered the phrase pickleball when they first developed the sport. So that's something else to be aware of. All right, so I've told you a little bit about the trademark process, why it's important. I do think there are lots of defensive reasons and lots of offensive reasons why people should take their trademarks very seriously. But who am I anyway? Like, who am I to talk about this stuff? Well, I graduated from law school way back in 2003, so a little over 20 years ago. I built my practice for about the first 10 or 12 years of my time as a lawyer, as a family law attorney. I did some other little things on the side. But starting in 2015, I started to transition into helping online entrepreneurs and online businesses, predominantly through LLCs, trademarks, contracts, all sorts of different things. And that's when I started my brand Hawthorn Law, which is kind of a You can't see my logo for my main law firm there, but the Hart Law Firm is my main law firm. Hawthorn Law is the brand that I used specifically for trademarks. So I began sharing my tips and information about trademarks and LLCs and all sorts of things that businesses can do to legally protect themselves on YouTube. In 2015, 2016, I started that, and I've grown my channel to over 171,000 subscribers and 8 million lifetime views at this point. And we've helped over 175 entrepreneurs in the past 3 years to protect and file their own trademark applications. So that's what I do. This is all we do at this point. Trademarks is what, like, 95% of my practice is trademarks. Getting those things filed, protecting people, filing oppositions, doing cancellations, doing all that type of stuff that comes with a trademark practice. That's what we do now. So let's get into the common myths that I kind of talked about at the very beginning that can cost you some serious money if you do it incorrectly. So myth number one is waiting until the time is right. This is something that we see from a lot of entrepreneurs. They want to wait until they're generating a little bit of revenue. They want to wait until maybe their brand gets a little bit bigger, and then they decide that they're going to go ahead and register their trademarks. Now, I say there is a lot of people think, what's the difference between registering your trademarks and trademarking a term? Well, you're not trademarking a term. You have a trademark. If you're using it, you want to make sure you register it. So if you've built a brand, you want to make sure you're registering that trademark. If you're waiting to register your trademark, then you're putting your brand at risk of being taken or stolen by somebody else. We do see stories on quite a regular basis of companies that will see other businesses that are doing something amazing, and they go ahead and they notice that business has not filed an application for their brand. And so companies will come in, they will file an application for the brand, and then they will send a cease and desist letter and demand a lot of money from the company that's actually using the brand in commerce to basically sell the rights to that trademark application. And I've seen situations where people spend or will be asked for $10, $20, $30,000 just to get rid of a trademark squatter, and nobody wants to deal with that. So the earlier you file your trademark application, the better. Common law rights, as we talked about with the Burger King example, are just not enough. Even state level rights are not enough. Federal protection is always going to be best. It's always going to be stronger. And you don't want to run the risk that some big national brand files a trademark application for a name that you're using and then pushes you out, or serves as kind of what's called a trademark bully. But the earlier you file, what will happen is you'll basically be securing your place in line with USPTO. Anybody who files after you, even though the process takes 12 to 18 months, it's basically a waiting. You're in line. So anyone who files after you, they're in line after you. Their application is going to get examined after yours. So you want to make sure you get your trademark application filed as quickly as possible. Again, I talked about Burger King. They thought that state level protection would be enough for them. It wasn't. And now they can only operate within 20 miles of, Mattoon, Illinois. If they wanted to expand their business into the rest of the state, which could have been what they wanted to do, that's no longer a possibility for them. All right. The truth here to this myth is filing early is the best strategy and is going to save you money in the long run. All right. So myth two is you use Google or you use a ChatGPT and you review the results there, and then you're like, you know what? Nobody's using my name, so I'm good. Just because you don't see your name in a Google search doesn't mean it's yours for the taking. Trademark conflicts can exist even if a name is not visible online. There's lots of businesses that register trademarks and they don't have a website. Believe it or not, even in this day and age, there's lots of businesses that just don't have a website. They might be operating at local flea markets. They might be doing mail order business that's referral only. They might be, sending out mailers to the general public, and then people, send their orders back in through, an order form that's online. So there's lots of ways where people could be using a trademark, but not necessarily have a website. I know it's crazy. People are like, wait a minute, people don't have a website, but it does happen. So just understand that many trademarks are filed but not used publicly. or not used on websites. The USPTO database is going to be the only authoritative source in terms of what trademarks are available and what trademarks are not available. But it can be tricky to search. The standard is not exact match, which most people think it's got to be an exact match search. No, it's likelihood of confusion. And many people that are not lawyers don't necessarily understand that means. I should say many people that are not trademark lawyers don't understand what that means, because there's regular lawyers that don't understand what that means. But unless you're doing this and you're trademarking lots of applications, you're doing searches on a regular basis like my firm does, it's really hard to understand the nuances of what goes into a search and what you're actually looking for, and being able to tell whether or not a name is actually available or not. So a proper clearance search can uncover hidden risks that you'll need to see before you actually invest in a brand. And as you know, once you start using a name, once you start investing in it, whether it's through content that you're putting online, whether it's through images you create, whether it's through an Instagram profile that you create that has lots of a backlog of images and content, whether it's ads that you're putting out there, it's expensive. And in building up that brand that people recognize, going through a rebranding exercise, as we saw with Plant Made, can be, $100,000 or more, and that doesn't count the legal fees that are associated with it if you have to deal with the cease and desist. So just doing a Google search for your name is not going to be sufficient. And as I mentioned, the USPTO database is very tricky to understand. All right, so only a professional clearance search can truly protect you. And so yeah. Myth 3. Now, the way I wanted to do this is not the way I'm going to be able to do it, but I suspect that all of you, if you look at any of these symbols on the left, pretty much anyone, even though none of them have, with the exception of McDonald's and American Airlines there, these are all registered trademarks, and these are all symbols that many of you recognize. I'm sure most of you recognize the red concentric circles as Target. I'm sure you recognize the Starbucks logo, and I'm sure you recognize the Apple logo. That's the power of a strong trademark, is that people will recognize your brand out in public, and they will recognize the source of your product or service. But not all names are created equal. Now, American Airlines is a great example of a kind of a generic name that has become ubiquitous in the marketplace, and therefore it is capable of trademark protection. Apple is an arbitrary name in that Apple, if they were opening an Apple store, then selling fruit, that's not something that would be able to be trademarked. But because they named their computer brand after an apple, that's an arbitrary name that is capable of trademark protection. Target is kind of a suggestive name, but it's a good name nonetheless. And obviously Starbucks is sort of a made-up name that can be used for trademark protection. So generic names like computer for computers can never be registered. That's one thing you need to understand. Descriptive names like creamy yogurt, which would describe the type of yogurt you're selling, are often refused also, unless they've acquired some sort of distinctiveness in the marketplace, which is how American Airlines was able to get their brand. It's very recognizable today. Everyone knows American Airlines is, a very recognizable brand. So suggestive, arbitrary, fanciful names are the strongest types of names. Suggestive, I would say, for small businesses are typically the strongest name, because it kind of suggests a quality or an aspect of your service or your product that the brand or that the marketplace can see. And obviously, the stronger your name, the stronger your legal rights, and it becomes more valuable for your brand in the long run. So that's the myth, that any name can be registered. That's not true. You want to make sure you pick a strong name for your trademark. I've gone through this process with a lot of my clients, so that's something that's very important. So strong names do equal strong protection. However, they also require a lot of money and capital to make people aware of. So, for example, a fanciful name that doesn't mean anything if people just say it out loud is something where you're probably going to have to put some money behind your advertising. Whereas a suggested name, which is why I really like suggested names, is something that kind of suggests a quality or component of what it is you're selling. And so you're not going to need to spend as much to educate the public on what it is that your brand is, because you'll just be able to ideally use it. So strong names equals strong protection. So let's get into, should you DIY it or should you hire a lawyer? Now there's certain people, yeah, maybe you should DIY it. I don't typically recommend it, but if you are on a tight budget and you don't have any extra money to spend on hiring a lawyer, if you're comfortable navigating the legal forms yourself, and I will tell you, it is complicated. They recently updated the trademark system. It's easier now than it was, but it's still tricky. And there's still a lot of choices that need to be made. So you need to be comfortable with that and following directions. If you're filing a low risk mark, so if it's a unique, fanciful name that is not going to be a problem to get registered, and you understand how to do a search, or you can, you understand what you're looking at when you do a search, then, maybe you could DIY it. If you understand the risk involved in filing yourself. I've seen so many people that come to me after they've filed their own trademark file or trademark application, and they have problems because they listed the wrong owner, they listed the wrong classes, they didn't use a broad enough description. There's all sorts of things that people do incorrectly when they're filing their own trademark application. And typically the office actions we see, an office action is an initial refusal from the trademark office. The office actions we see from people that file their own applications are much more in-depth, require a much bigger response. And frankly, that's more than anyone who's trying to do this on their own can actually handle. So who should hire a lawyer? Well, if you want peace of mind and expert guidance, you should definitely hire a lawyer. If your brand is valuable or already in use, you want to make sure you do this the right way. You don't want to waste 8 or 10 months of your life waiting for the trademark office to issue a denial for you, where then you might lose your place in line if you had to refile. If you're not sure about your name strength, or you're not sure if you've done a search and you're not sure whether or not your name is actually available, you probably should hire a lawyer to do that. If you don't want to risk the costly mistakes or delays that come from doing it yourself, you definitely want to hire a lawyer. And if you're unwilling to just risk, filing the application yourself and potentially making a huge mistake down the road, then yes, you definitely want to file the application with the help of a lawyer. The trademark application, I would say, is deceptively easy. It doesn't seem like it asks for a whole lot of information, but there's so many different places where you can get tripped up, and I'll probably talk about that on a future webinar. But it can be very tricky, so you want to make sure you're not making that mistake. So what's next? Well, I want to tell you a little bit about how we work. I'd say 95% of the work we do here at Hawthorn Law is we work with coaches, creators, online influencers, small businesses to help them protect their brands. We never charge by the hour. Everything we do is a flat fee that we agree to in advance with our clients, so you always know where you stand with us in terms of your fees. You never have to worry about getting a bill at the end of the month and for a bunch of services that you didn't even anticipate. We always reach agreement up front. We use a secure client portal that keeps our clients up to date on the process of their application. And we don't charge for, I do say reasonable email correspondence, because I have had people abuse that in the past. By abuse, I mean sending like 5 or 6 messages a day, every single day. That is not reasonable. But occasional messages, you got questions, you need to schedule a call, whatever, that's all included with our packages with our clients. So whether it's reasonable email correspondence, messaging, or you want to schedule a call with me to go through your application, we do all that with no additional fees related to that. What our clients say about us. So I kept the names out of these to protect them, but if you want to see a whole list of reviews, feel free to go over to Google, just type the Hart Law Firm Raleigh, and you can see we've got over 50 reviews, 5-star reviews, the vast majority of which are 5 stars, but you can see The first review at the top there, I can attest to Mr. Hart being top notch. He makes the process easy and stress-free. The next one, they have been working with Jim and his firm for a year. They've always been great communicators, very professional. They've updated me on every single month on time, which that is something we do. We send out monthly updates to all our clients. And the next one, James and his team are the ultimate professionals. They know their stuff and are very effective at getting things done. Finally, I had a wonderful experience working with Jim. I think they meant to say Tana, that's my legal assistant, and Coleman, who is another person on our team, on our trademark application. So yeah, people have a lot of nice things to say about us. I appreciate it. So here's how our process works. We basically, we've broken down the trademark process into 3 phases. I'm not going to talk about the 3rd phase today because that's what we do after the trademark registers. But the first 2 phases, the first phase is we conduct a comprehensive search and draft a legal opinion for you. So we're going to do a search. We're going to use some software that we use that we pay a lot of money for each month to run your name through that software. And then we're going to basically draft a legal opinion, 3 or 4 pages that will talk with you about the merits of your proposed name. If you're doing a logo search, we will do a search of the logo database at the USPTO, which is a little bit more tricky. I'm not going to get into that here today. And that's a $497 value for that initial search. Then we do a strategy call with our clients to review the search and determine the best way to proceed. Oftentimes, the client decides they want to move forward with the trademark application. That's what we're looking for. That's what we hope for. Sometimes we're not quite sure how to proceed, so we'll give the client options or tell them, what they might see or could expect if they do proceed with their trademark application. And then in some cases, the results are clear and we tell our clients they should not move forward with their name. And in those cases, we, let them know you shouldn't move forward with your name. And that's fine. And if the result is negative, then we will go ahead and conduct a second search with a different name or logo for no additional charge. So again, that's a $1247 value. So you're looking at, between $1250 and $2,500 for phase 1 in terms of the value that we provide. And again, I mentioned throughout this entire process, we're available for messaging, email, and to schedule other calls if you have other questions during the process. Phase 2 is where we prepare, file, and monitor your application. So the application process takes around 12 to 18 months, and this kicks that all off. We're going to prepare your application. We'll help you to determine which classes to file in. We will draft your descriptions in a way that will optimize your chance of success. We'll give you flexibility in the future, and we'll also minimize the trademark fees. So the trademark fees can vary between $350 to $750 per class that you include on your application. Again, that's beyond the scope of this presentation today, but I'm happy to talk with you about that at the end during the Q&A if you do have questions. We're going to help you determine who should own your trademark. This is a mistake that a lot of people make, is listing the wrong owner. And then we'll file your trademark application and monitor it. So this whole value is, roughly $1,500 for the whole process. And so here's some more comments of what some clients have said about us. They're extremely professional, knowledgeable, kind, and so incredibly fast. No days without answers to correspondence. Yeah, we take pride in that. We have a client portal, a client app that the clients use to communicate with us. And that's the first thing I do every single morning is log in and answer questions from clients about what's going on with their application, about questions they might have, different things like that. And like I said, if it's something that's beyond the scope of what we can talk about in a simple message thread, we'll just go ahead and send a link for you to schedule a call with me. And we do those all the time for no additional charge. The next review, working with you was a pleasure and the process was easy. And then finally, I'd wholeheartedly recommend working with this firm for trademarking and business law matters. So, and there's, like I said, a bunch of other reviews out there. If you just want to Google our name, reviews, you'll find them. We also have a number of reviews on Trustpilot as well. So Why would you use our firm? Well, we're going to minimize the risk that your trademark is going to be rejected. Like I said, for people that DIY their trademark, we typically see big denials, lots of issues, lots of mistakes that people make. Sometimes they can be fixed, oftentimes they can't, and the client would have to start over with a trademark from scratch. We don't want that. So we're going to monitor your trademark throughout the entire process so that you don't have to worry about responding to time-sensitive requests from the trademark office. We're going to file responses to minor office actions for no charge. And we're going to be available to you for ongoing questions and strategy regarding your trademark until your mark either registers or you receive a notice of allowance. So those are the two different ways that your trademark application with us will end. But then we do move into, like I said, phase 3, which is where we may need to file extensions or renewal documents or different things like that. And we have a subscription service that helps deal with that. So you can sleep easier and focus your efforts on your business, growing your business, building your business, while knowing that your trademark application is in good hands. You know, most of you that are attending this call, you're not lawyers, you're entrepreneurs, you're trying to build something amazing for you and your family. And you need to spend your time and money and expertise doing what you do best, which is building your business, not filing trademark applications, even though you do need to worry about filing trademark applications, obviously. So as a special offer, our typical fees for phase 1 are $1,250 and phase 2 is $1,500 for a total fee of $2,750. That does not include the trademark filing fees. If you schedule a paid strategy call within the next 72 hours, we will credit the cost of that call against your legal fees. So that's a $250 value. Real quick, Coach C says, I did this and the process was super helpful, quick and easy. I procrastinated for 15 years and finally with Jim's help, I got it done. I'm not getting paid to say this. No, Coach Constance, you're great. Yeah, we did help you and it's been a pleasure working with you for many years now. So if you schedule a paid strategy call within the next 72 hours, we will credit the cost of that call against your legal fees. In addition, if you hire us after the strategy call, so in other words, you pay the $250, you get in the call on us, we'll knock off an additional $500 off the price of your trademark application. So then you'll be able to pay in 4 installments of $500 each. I do not offer that to most people. Most people that hire us, we ask for the full payment up front when they hire us. I've not done payment plans in years, but as a special offer to people that are attending the call today, we're going to do 4 installments of $500 each. So our typical fees look like this. Trademark strategy call, $250. Search and opinion, $1,250. Preparing and filing and monitoring your application, $1,500. Total investment, $3,000 due up front. For people that would like to join us today, the strategy call is $250. You do have to pay for that. But then from there, the trademark search and opinion will be $875. The preparing, filing, and monitoring your application will be $1,125. So the total investment, if I did all the math right, is $250 for the strategy call and then $500 when you decide to hire us for the trademark, and that can be made in 4 equal payments, so you don't have to pay the full $2,000 upfront. So that's $750 off the total normal investment that somebody would make. You can go to hawthornlaw.net/webinar call, and I'm going to go ahead and I think I can add an offer here. And then I'm going to open it up for questions. So if you want to post your questions into the Q&A box, I'm happy to answer them. All right, so I think I should have the offer up. And I'm happy to answer questions. I'm going to go back to the chat. All right, question from Stan. Does a newsletter title need to be trademarked? That's a good question, Stan. It depends, maybe. So by newsletter, I don't know if you mean like an electronic newsletter, if you mean like something that you send out in the mail. I would look at that as almost a periodical. So we do have some clients that have registered their business is basically, how do I say this without giving too much information about the client away? It's basically like a home decor magazine, and so we registered the name and the logo related to the magazine, and it's an ongoing periodical. And so yes, that is definitely something that can be registered, and that's definitely something we would register. Like if you look at like a Sports Illustrated, for example, I suspect that's a trademark. I don't know for sure. Or Time Magazine, I suspect that's also a trademark. Digital newsletter, Stan, I don't know if this is just something that's going out as an email or if you're going to format it with images and photos. I mean, yes, if this is something that people are paying for and it's being used in commerce and it's a brand that I've seen this. Another good example with this would be, I think it's the Money with Katie newsletter comes out. There's I think is the business, maybe the brand that sends out newsletters on a variety of topics, and they do charge for that. There's an annual subscription. So yes, that's definitely something that I think would be good for trademarking, for registering as a trademark. Yes. What other questions do people have? I'm happy to answer as long as people would like. So just to be clear, this link right here, hawthornlaw.net/webinar call, is only to schedule a call with me. During that call, we'll kind of go over your business. We'll talk about what you're up to. We'll talk about your brand. We'll talk about your products. We'll talk about like what you're up to, and we'll talk about whether or not registering a trademark for your business actually makes sense. So, and if it does, at the end of that call, then you'll have the opportunity to hire us and save an additional $500 because I will credit the cost of the call against your retainer. So instead of $2,250, you only pay $2,000. And then again, instead of having to pay $2,000 up front, you will be able to pay in 4 monthly installments of $500. So we want to make it as easy as possible for people to move forward with our firm. Miss Mez says, can you trademark an avatar image likeness of yourself for your logo? So that's a good question. The short answer is yes. The more long answer would be it depends. And it depends because if it was created with AI, AI images are not copyrightable. Are AI images trademarkable? Potentially, if they're being used in connection with your brand. So if you have a logo and you've got like an avatar image of yourself, and we've seen this before, it's no different than trying to think of a good example, like a superhero. Those can be trademarked. Like if you had a service-based business that had an image of like a superhero that was used in connection with your service-based business, then yes. Ms. Mez, you say no AI was used. Yeah, if no AI was used and you kind of created on your own, then you shouldn't have any issues with that. I will let you know, we have about 15 minutes left on this presentation before it's going to shut down. So I'm happy to continue answering questions, but yeah, so you should be able to. I like to, whenever I'm dealing with logos, I like to look at those for my clients and give them some advice and guidance on them before we actually move forward with an application. So I'd need to see it, but that's something we could certainly talk about and review on a strategy call if you wanted to schedule that. Okay, so Stefania, my question is it easier to get approved once a trademark has already been approved by a different organization since EU IPO? So, so the short answer is maybe. And the reason I say maybe is because if you have an international trademark that you're looking to register in the United States, and I've done this for several clients, there's a separate filing status that we can use for that. And you don't have to show use in commerce in the United States. You only have to show that you have a registration in another country. So if you already have that registration granted in another country, you can file your application in the US and you can piggyback off that registration in the other country. The only caveat being you still have to go the process of doing a search. You still have to know that your name is capable of being trademarked in the United States. If there's any problems along those lines, then you're not going to be able to register it. If it's likely to be confused with an existing trademark, you're not going to be able to register it. So as long as that's not a problem, yes, and it should make it easier to do the whole process. But we'd still have to do the search here first. So it does make it slightly easier, but it's not 100% foolproof. The other benefit too, if you have a registration filed in another country, you have 6 months from the date you file that registration to file in any other country you want that's party to the Madrid Protocol, and then your application date will revert back to the date you initially filed your application in that other country. So this is a question that comes up, like I have clients that want to file in the United States, but then they also want to file in Europe. They want to know if they file in the United States, can they use that to piggyback off their application in Europe? And the answer is yes. However, in Europe, oftentimes the trademark process is a lot faster than the United States. And so when you file in the United States, and then let's say 2-3 months later, you file in Europe, if somebody else had filed after you filed your application here in the United States, they would have priority. But because you already have an existing application on file with the United States, you can attach that to your application, like in Europe, for example, or Australia or Canada or wherever, and it'll revert the date of your application back to the date that you originally filed in the United States. So you'll leapfrog a bunch of other people that may have jumped in the line ahead of you. Hopefully that helps. Miss Mess says, thumbs up. Good. I'm glad that was helpful. All right. Any other questions? I'll stay on for a few more minutes. Like I said, we're going to get cut off probably here at the top of the hour, but I'm happy to answer any other questions people might have. And again, I apologize for being a little bit late to the call today. Technical glitches, just trying to figure it out. Stefania says, thank you. All right, I hope that was helpful, Stefania. Yeah, we have worked with clients in Brazil. We've worked with clients in the UK. We worked with clients in Germany to help them file their trademarks here in the United States. We've worked with clients in Portugal. So yeah, we're happy to help with that situation. Any other questions? All right, well, I'm giving it about 15 seconds because I believe there's a delay between when I talk and when somebody answers a question on here. Ms. Mez says, thank you so much. James, definitely appreciate your time and help. We'll keep in touch. That sounds great. Love to hear from you. And yeah, thank you everyone for attending today. I appreciate it. I know this was kind of a last minute thing. I just wanted to test this out and see if it worked. So far, so good. If you would like to go ahead and use that link to schedule a call, I'm going to leave that up for about 24, 48 hours, and then we're going to take it down. Stan says, excellent webinar. Thanks, Jim. Thank you. I appreciate it. And look forward to chatting with you all in the future, hopefully on a strategy call and hopefully helping you to protect your trademarks. Thanks, everyone. Have a great day.